Alrighty, so this is a very quick one. So this is about legal considerations. So there's only a few things you really need to know about legal considerations to form the foundation of what's required for Unit 3 and 4. So I'm going to go over this. There is a huge amount of information with regards to copyright, trademark and patent, which I'm going to be talking about online. So if you're seeking to do more research onto this or seeking alternate answers, perhaps to specific patents or copyright or trademark infringements or logos or brands that utilize such intellectual property protection, make sure you always try to reference legitimate Australian sources, because such intellectual property can be different from country to country. So if you're doing your own research, please make sure that you ensure that you're looking at an Australian site, and preferably a .gov site, so that you can trust that information, because there's a lot of misinformation out there as well. So basically, the types of intellectual property that I'm going to be discussing today are copyright, which is inherited automatically on the completion of any tangible design, not an idea. Very, very important that you remember that you can't just say that you thought of that first. It needs to be something tangible. So remember that as a side note. Trademark, so the legal protection of marks which distinguish a company, and then patents and design registration, which is the legal protection of ideas and designs. So patents largely exist in the industrial design space. All right, so the first one I'm going to talk about is copyright. So copyright is automatically granted to an individual regardless of whether they operate commercially as an artist. So once they have completed their artwork, let's say. So it can be in any form. It just needs to be tangible. So that can include photography or video. It can include songs, or what we refer to as sound bites. It can refer to digital or manual illustration. It can refer to any completed piece of writing. So that could be a poem, it could be a book, a novel, it could be a journal entry, any type of completed piece of writing. And also a logo design. Now there's a bit of a grey area with logo design, because that's also often protected and falls under the theme of trademark, which I'm going to be talking on shortly. And the only main thing that we really need to remember with copyright is that even though it's granted automatically upon the completion of any given artwork or art form, it needs to be original in its nature. So you can't just draw a picture of Mickey Mouse and expect to be protected under copyright for anybody else that draws a Mickey Mouse. For instance, if I was to provide a hyperbolic anecdote. So yeah, going back to logo design, the logo design is protected under copyright, but as it sits exactly how it's drawn with perhaps the exact words, that is what would be protected under copyright. So it doesn't necessarily protect you from another company producing quite a similar logo. The other thing with logos is, of course, it would need to be quite unique. You can't just draw an A and expect to run around suing any company that has an A in their logo. So that's copyright. Pretty simple one. It's automatically granted, and it protects almost any finished design in any form. So that's your copyright. So the question that you would have there is, what if you do want to share your work? What if you produce a soundbite, or what if you produce a piece of writing or a meme that you want the world to share? You want to be famous for your amazing design, or you just you're very altruistic. You might have produced some sort of design which you feel would make the world a better place. And a lot of people are doing that. There is the rise of companies like Wikipedia. There's a lot of free font websites where people just design because they want to share their expertise or their knowledge or their experiences with the world. And I think that's a fantastic thing. Um, so people who wish to do that, they can either just not just tell everybody to please share it, and they won't pursue. That's kind of an unofficial way of sharing your design with the world. Otherwise, an official way to do it is through Creative Commons. So that's basically a license that you can provide to people to say, yeah, you are people are welcome to share this. But often the Creative Commons, you get the opportunity to share your work under special provisions. So I'm going to briefly touch on those provisions now. Now, this was based on an American site. The Creative Commons licenses are very similar, but the wording is slightly different. So, but this just gives you a bit of an idea of the sort of things that you have control of under Creative Commons. So, if you wish to allow people to redistribute your work, that's the main thing for Creative Commons. The second thing is that you might really want people to redistribute your work, but you might also kind of feel that it's fair that they attribute you to being the original owner of the work. So you can say, yep, please, under Creative Commons, please share my work, redistribute it, do whatever you like with it, but let people know that I was the one that designed it in the first place. The other one is you can say, yep, under Creative Commons, you can use it. You don't need to attribute me, but I don't want you to make any money from it. I think that that's unfair. So under the Creative Commons, you can stipulate with that license to say, yep, anybody can use it for private use, but if you're planning on making some money, I'd like you to contact me so that I can approve such things. There are other things that you can protect. So you can, if you produce a drawing, mainly perhaps for a political cause, or you've got really strong political persuasions, you can release, say, a music or a song that you wrote, and you can say, yep, look, I'm free, you can use it, you can even use it commercially, I don't care. However, if you modify or adapt that original work, so say if you're heavily leaning towards, say, the Greens Party, as an anecdote off the top of my head, you might want to control or restrict your song so that it can't be modified in a manner which perhaps promotes the Liberal Party. If I was to provide an anecdote there, so you can have control to say no, you are only allowed to use this in its original source and for its intended purpose, which is to promote this party instead of that party. If I was to come up with something there, so you can use it, but you can't modify it and adapt it to a different purpose other than what's intended or different to the way that you hoped it would be conveyed to your audience. So that's effectively those Creative Commons. You don't need to know a huge amount about that, but just be aware that there's lots of different licenses where you can have control over how people use your work if you wish to share it. So the next one we're going to move on to is trademark. So trademark is the little TM sign that you've seen, I'm sure, a million different times. Goes on the end of a logo, an image, a tagline, a symbol that represents a company. The TM mostly serves as a warning to other companies that they are not legally allowed to imitate their brands by replicating the unique and recognizable features of the brand. So trademarks can include a lot of different things. So it's not a specific tangible thing like I suppose copyright is. It's more a philosophy, or and it's kind of unique to each company and how they feel their company is recognizable. So one of the more obscure ones that doesn't happen very often are color trademarks. So an example of that is that no other chocolate company is allowed to use Cadbury's purple on their products. So you're not allowed to release a chocolate bar that's purple because Cadbury and the eyes of the law would see that as you trying to pass off your chocolate bar as a Cadbury product, which means that you would be able to draw on the trust in the Cadbury brand, so to sell your product, which is obviously not legal, and Cadbury would come down on you quite hard around that. There are symbol trademarks, so this wouldn't necessarily the exact shape of, say, if we were to look at the Qantas kangaroo, the exact shape of the Qantas kangaroo would probably be trademarked, but it's also protected under copyright. What Qantas trademark would be the use of a kangaroo on the tail of an aeroplane. So that's what the trademark is depicting. So the copyright would stop you from doing exactly that kangaroo on a red plane, but the trademark is more protecting, saying, well, no other airline can draw a kangaroo on the tip of the aeroplanes, because that would imply some sort of affiliation with the Qantas name. So that's more of how a symbol trademark works. You've got shape or form trademarks. They're referred to as shape trademarks, but of course we discuss any three-dimensional object as a form in if we're referencing design elements. So an example of that is the contour bottle. So Coca-Cola, very, very old trademark where you've got this nice, neatly curved bottle, which they protect very rigorously. There are very similar bottles out there. If you were to look at, say, any of the Pepsi brands, you can see they're quite similar, but none of them have that contour that represents Coca-Cola as a brand, or that makes Coca-Cola unique and identifiable in the marketplace. There are certification trademarks. So they're trademarks that specifically can appear on many, many different brands, say like the Heart Foundation or some sort of a fair trade or organic tick of approval or certification. So certification trademarks basically mean that you have to seek certification from that company in order to use that certification trademark, or imply that your brand or your product is certified under the regulations, I suppose, of that certification. So an example of that is, of course, Woolmark. If you were to produce a wool product, you would need to seek certification from Woolmark to use that logo on your apparel. So that's certification trademarks. And finally is series trademarks. So that's when a company, so say maybe a clothing company, they're called, Damien Clothes. You can create a series of perhaps Damien shoes, Damien pants, Damien sportswear. So you can create a series, and you can protect that series so that somebody else can't come along and say, oh, well, I'm just going to create a brand Damien socks and pass my brand off as kind of being part of the Damien clothing series. So Strongbow have done that. They've got a series trademarked on their ciders, where each cider is represented by this different colour. And of course, they would be legally allowed to protect any instance where somebody was to create a third colour, so say like a blue, and put a little tree on their little blue ciders and imply that their cider is part of this Strongbow series of or range of drinks. So that's trademark. So getting a trademark is very different to copyright. Copyright is, of course, just granted automatically upon the completion of any given design, tangible design, whereas trademark is a real process. One of the reasons it's such a process is because it's much easier to contest a trademark in the Australia's legal system, so in court, because you've kind of done all of the groundwork beforehand. So the first thing that you need to do is, in order to get a trademark, is ensure that your design or your unique selling feature or your unique aesthetic feature is entirely unique to the market. So the term ubiquitous is probably the worst term that you'd want to hear if you're applying to a trademark. They turn around and they say, no, this you can't just trademark a sandwich having a top and a bottom, bread on the top and the bottom, because that's ubiquitous. People have already done it. It's already common in the marketplace, and it's not different enough. So it must be completely unique in order to be trademarkable in the first place. And then the second thing, this is a bit of an interesting one, that the TM itself doesn't actually imply any legal grounding whatsoever. It's the R that does that, but the TM basically tells company that you intend on or already have trademarked your brand. So you put that little TM to say, hey guys, watch out, I'm protecting this. So it doesn't specifically state legal grounds. It's just a bit of a warning flare to other people to say, yeah, hey, let's don't copy me here because I'm planning on. Or you could just keep it on there if you already have. But in and of itself, you can just put a TM on anything and it doesn't really mean anything. So the third thing is that you would apply for that trademark. So you can go through the application process yourself. It's quite complex and convoluted, and you need to know a huge amount about intellectual property law to effectively get a trademark through, because there are so many hoops as far as what you can jump through. And you might end up finding that only a tiny little portion of your logo, so say a very specific combination of colors and letters or particular items, can be trademarked. And if you try to do that yourself, you can kind of find that yourself getting in trouble, because often trademarks that you do without really knowing exactly how a trademark works, lawyers will see that and they'll say, yeah, I can easily get around this. And you'll find that your trademark isn't really worth anything. So generally you'd want to employ the service of a highly qualified lawyer to ensure that you're best protected under your trademark. Once that's all done, you've officially got yourself a registered trademark, and you can put the little R or you can keep your little TM, but basically that means that any company trying to emulate that particular look or feel or shape or form or whatever, you do have grounds to very, very easily take them to court if it can be proven that they have replicated that trademark. And then the final thing is just to make sure you keep your trademark current. So your trademark generally will last 10 years and you've got 12 months. So on the 9th year, you've got basically 12 months to renew your trademark. Or you can just lose your trademark. If you're no longer profiting from it, you can just let it lapse, and then all of a sudden people can jump on board and start replicating your product. So that's getting a trademark. The final one I'm going to talk about is patents. So patents provide protection against unlawful copying of designs of functions relating to industrial designs. So patents effectively protect people who invent things. So they allow them the ability to manage who is able to replicate their ideas. They may choose to make and sell their patented design themselves exclusively. An example of this is, I suppose, perhaps Dyson. They've got a lot of patents on their designs. I think James Dyson is his name. And he, of course, designs and builds his own products and then patents them and exclusively sells them. Other patents may involve perhaps an inventor that doesn't want to be a business person. They will design and patent a function or a feature or even a chemical combination or a snippet of code, and then just sell that patented technology to whoever may benefit from it, say Google, for instance, often for a fee. Very seldom would you bother patenting something if you were planning on giving it away for free. One of the earlier examples of a patent is the light bulb. There was a huge amount of patents back in that era because we were just kind of hitting this scientific revolution and inventors were popping up everywhere, and patent was the big word that kind of underpinned the capitalist system and made people, it inspired them to invent, because patents were quite easy to get back then because nothing much had been invented. Bluetooth technology is one that you might not have guessed is patented. So the technology of how that information is transmitted via wireless beams is patented under Bluetooth. There are, of course, other ways. I think Red Ant was one that didn't really work so super well. Wi-Fi is another one, of course. Google PageRank algorithm. So that's probably patented on two fronts. One is exactly what it does and how it works, and the other patent might be on a particular snippet of code which makes the system work. So that would probably be referred to as a trade secret, I suppose, a trade secret style patent. The other one is phone designs. Now, you would have heard this a lot. Samsung and Apple are quite litigious in nature, so they would very, very quickly jump on board and try to sue one another all the time about one phone looking a bit too much like the other one, or having this similar feature or function, maybe the blurring out of the background, or the beautifying of a face on the camera, or the interface. So they would have, I'm sure they would have thousands of patents out there for every single little aspect of their phone, and they've probably got people buying the latest Samsung every time it gets released to the market, and then just going through it with a fine-tooth comb and seeing what they can sue Samsung for next, or vice versa. And then there are also aspects of Lego. Now, that's an interesting one as well, because the building block in that clip-in system is not actually necessarily protected under patent. There are only a few unique aspects of Lego which are protected under patent. And I believe that they're the little circles underneath, which mean that you can connect the little bits offset or as a group. So that's particularly what Lego is protected under, because believe it or not, most of the shape of Lego was actually already existing in the market. So Lego only really added a couple of new things to make it really work well, and then they put the patent on that. And then, of course, they had the perfect combination of inventions, which they were able to patent and of course, launch an empire. So the only one more thing that I'm going to talk about, so you've got those legal obligations, but you've also got some moral and contractual obligations. So if you were to consider, let's say, a moral obligation can include modifying the work of a designer which you've utilized for a project in a manner which is detrimental on their image and style. So that's a little bit under that sort of Creative Commons protection. So you might be granted permission to use perhaps the script for a theatrical production, but you've got that moral obligation to make sure that that script is replicated in a way that celebrates how the original artist intended that theatre production to be carried out. So if you're provided with that sort of copyright provision to use their work, you do have that moral obligation to make sure that you use that work in a manner which the artist intended, and certainly not in a manner which degrades or has a detrimental effect on the image and style intended, or the image of that particular artist. So contractual obligations are also some form of legal obligations. So if you were to purchase perhaps a trade secret, so say you by some miracle Google granted you permission to use their snippet of code for page rankings, those trade secrets are normally protected under some sort of contractual obligation, such as a non-disclosure agreement. So that basically absolves you of any rights to distribute what you have purchased or distribute the secrets of what you've purchased, making sure that you only use it for the purposes which are detailed within a contract. So there's so much to know about all of this legal considerations. I hope I've been able to give you a bit of an insight into how this all works. It's extremely complicated, so I've glossed over a lot of it. Hopefully I've given you enough so that you know the general crux of it. But of course, there is an entire industry of lawyers and attorneys and the entire court system around this, and millions of pages. So this is just absolutely skimming the surface of copyright, but hopefully it gives you enough to know how copyright works, particularly in the design industry, and being able to identify what copyright, trademark, and patents are, how they can be attained, and roughly what they can protect.